Welcome everyone. Thanks for making the time to join in this morning. For those who don't know me, my name is Albert Ferraloro. I'm a principal at Wrays and I head up the Management and Strategic Services Division. And today I'm just going to give you a very quick walkthrough of some essential items that I believe need to belong in an IP toolkit. So there's a bit of an assumption here that because you're joining into this webinar, you have some IP, you acknowledge that it needs to be managed. Hopefully you've got a bit of an IP framework or some management practices in place, and you're just wanting to get an idea of what else you can do to help safeguard and extract value from that IP. So that's the base I'm starting from. I won't be going through, the difference between a patent and a trademark and copyright. We've done that in other webinars, which I'm sure you can access in other ways. But we're just doing a bit of a deeper dive into what that IP management toolkit will look like. So these are my aims, some quick initial reminders about IP management that I always do, sort of my soapboxy items. I'll highlight some of the IP toolkits items that I tend to draw upon every time I help a new client. Time permitting, I've got some other good to haves that I'm happy to share with you, and obviously attend to any questions that people might have at the end. So just in terms of those initial reminders, hopefully everyone on this webinar is already aware that IP should be treated like any other business asset. It's very important and can add value in a number of ways. And in the same way that we have policies and practices around what our employees do and how we safeguard our machines and our buildings, we also need to make sure we're looking after our intellectual property assets. I also like to dispel the myth that this is just to talk about patents. Patents will come up as one of the formal IP rights that you might use, but IP to me as a management strategy person is a very broad thing, and you'll see the number of categories there on the slide. And depending upon what your business is seeking to achieve, some of these are going to be more important than others, and what belongs in your IP toolkit and your IP framework will be different from organisation to organisation, because you'll be targeting whatever, the software or the know-how more than the inventions or the trade names, whatever it is to suit what you're seeking to achieve. Just in terms of that IP framework, and this was presented in an earlier IP in Focus webinar that I delivered a few weeks ago, there's a lot that you can focus on when you're looking to have a bit of a management strategy and some practices around looking after your IP. These are the 10 that I've sort of summarized as my 10 commandments. I tend to come to these quite often when I'm assisting clients. Often we'll focus on 5 or 6 of them, but these are the ones that come up a lot. There's probably another 6 or 7 things that I could throw into an IP management framework if we're talking about a very large and a very sophisticated portfolio. But these are the main ones. And today I'm just going to delve into a couple of these in terms of some of those processes or actual toolbox items or documents that I tend to roll out when I work with organisations who are trying to bolster how they look after their IP. So in particular, I'm going to go through some materials around identification and capture, evaluation in particular. I'll make some comments about IP ownership and the IP landscape, and also those defensive measures that can be in place. Now, that's not to say that there aren't other mechanisms and tools that exist for those other points I'm not going to delve into, but recognising that we've got about 30 minutes, I'm just going to hit those ones that I tend to come across more and more as the key items that I would roll out. So IP capture, I guess for those that have heard me speak before, you'll recognise that I've got a phone ringing in the background, so I'm hoping that's going to get answered really quickly. I always talk about IP capture as the first thing that I hit. You've probably heard me say that without IP capture and identification that goes with it, there is really no discussion about IP management or leveraging my IP assets. That can't happen if you don't know what you have. So IP capture to me is one of those really critical ones that you need to get right. How you codify what your IP is going to be different from organisation to organisation. And on the slide there, you'll see some different examples. I've seen organisations that have a good intranet, and they'll put a little portal up there where their employees can log into a little design note and make some entries about what was created, particular dates, and that's quite good. Obviously, the obligatory laboratory notebooks that larger research organisations have is a good way of codifying different solutions that are devised along the way. But I guess the one I fall back on quite often and almost always, if I'm starting from ground zero, is an invention disclosure document, or an innovation disclosure document, as this one's called. I guess a simple form that helps collect people's thoughts about a solution, codifies them in a way where that information is going to be useful later, either to reflect that that proprietary information was existing at the organisation as at a particular date, or to share with a patent attorney or your R&D tax provider, a really good snapshot in time of what's going on with a particular solution. That invention disclosure document, in my ideal world, is capturing things like what the problem was, in very simple terms, what the solution is there any anticipated disclosure, when was it conceived, who the inventors or the creators were, any detail that's able to be shared in the form of drawings, other advantages or disadvantages, other markets that it might open up. These are the sorts of prods and questions that a good invention or innovation disclosure document should provide. They're not meant to be a burden. So this is quite an old one. It's electronic, but it was quite wordy in terms of what it was requesting of people. Some more advanced ones that I've developed for clients have a lot of drop down and selection boxes. So much easier to fill in with people just having a look at a tab, a drop down menu, clicking what's appropriate, and populating this document. Really good way of capturing know-how, and a really good starting point for, providing those foundations around IP and IP management that are going to grow with the business as it moves forward. I guess the IP or the invention disclosure document then goes hand in hand with a decent IP register. This is just a simple one. This is just an Excel sheet that's recording details from invention disclosure documents that have been submitted and capturing them in a way that's going to be useful down the track, particularly if you start dealing with investors or M&A targets or acquirers who want to know what IP you've got. Having a nice populated IP register is a great way to reflect the value that sits in that IP asset space for you. So rather than just saying, oh yeah, we've got know-how and trade secrets, you can actually furnish them with a copy of an IP register showing a lot of the solutions that you have. And in my ideal world of IP management, each line item on this register would be backed up by something like an invention disclosure document. Goes without saying, a good IP register probably then has similar types of recordal sheets for things like your trademarks, both formal filings that have happened and unregistered trademarks, domain names, non-disclosure agreements, other agreements, formal filings like patents, designs. They can all be captured in similar sheets and put together in a nice workbook, and you've got a very effective register capturing a lot of information about what you've got in the IP space, and obviously able to provide you with different reports at different times, like this one here you see on the screen, snapshot in time of the know-how that a company has. So really important to have a strong and solid IP register, because down the track, if anything happens in terms of you trying to leverage your IP assets, you're invariably going to have to display or produce something like this. Once we've got our IP and we know what it is, I guess it's important to be able to evaluate and make decisions around what may be kept as a trade secret, what shouldn't be shared, what could be filed in a formal manner, perhaps as a patent or a design registration. And often that will just fall to a person or someone responsible for making those decisions, often the person with the loudest voice. And that's typically the case in smaller organizations. But the more sophisticated companies typically have some tools that help them make those decisions less subjective, more reliable and more repeatable. So things like simple flow sheets, which can walk them through to a typical decision about, is this a trade secret thing, or is this a filing, or do we have to send this back for more information? And the more sophisticated ones will typically have some sort of checklist or matrix that they use to score or rank different inventions. So what you see on the right there, an IDD ranking checklist. I've rolled this out at numerous organisations where they have something, in the order of more than 10 IDDs collected over the course of a year. They don't have the funds to formally protect everything that's recorded in an IDD and need to make some decisions about which ones sit ahead of others. So having a checklist or a matrix which can walk you through some commercial considerations, some technical considerations, applicability, use considerations, and also some IP considerations, and give you a score, then you can effectively come up with a league table of invention disclosure documents. A really good way of removing that subjectivity. Often if you get someone invested in a particular idea sitting around the table assisting with the decision, there's often bias, but where you have tools like this, to a certain extent you can eliminate that bias. So really good toolbox items to have. Again, we're assuming here that there's a body of IP that needs to be evaluated. If you've got one solution, it's pretty easy. Have a chat with your service provider. Do I formally protect or do I keep it as a secret? This is for organisations that are starting to acquire and develop more and more solutions, more and more IP assets. Ownership is another one of those big soapbox items. And for me, it's about making sure that any external parties you deal with, you are making sure that you get access to any IP rights that are developed, whether that's full ownership or whether that's license rights that enable you to do what you need to do to take your business forward. So for mine, there should always be a really good service agreement document that you can leverage in the background. And ideally, this is a bespoke document that's created for you at least once by an IP lawyer or commercial lawyer that you can leverage over and over again each time you engage a creative that's external to your organisation. Sometimes they'll hit you with their service agreement, and that's fine. I guess the main thing is that you've got something to draw on if you're the one making the engagement, and you can provide a starting point that captures all the elements that are important for your business. And that's why it's important to have at least one crack at getting a bespoke document prepared for you, rather than just grabbing one from a colleague in a different business. I know a lot of organisations do that to save money, and often you can get away with that. But you do need to be careful that you're capturing the right elements and that they're reflected in an agreement that are important to your business. Also goes without saying here that that employment contract that's in place for your employees is also saying the right things about confidential treatment of information, return of information when people depart the organisation, and importantly, what happens with IP in terms of ownership and access. I've learned not to assume that everyone has a good employment agreement in the background. Often it'll just say, this is what you get paid, this is where lunch is, and here's a few HR things you need to be mindful of, and it doesn't say anything about IP. So in the same way that you have a good pro forma service agreement that you can draw on in your IP toolkit, do make sure that your IP, that your employment agreements are also up to scratch and say the right things about IP and that is retained within the organisation. In terms of those defensive mechanisms, often the free things that you can be doing to safeguard your IP, there's a number of things in the toolbox, right down to the simple things like recognising those different marking notations that you should be using, those copyright labels and warnings, those confidentiality footers, knowing what that language is, and reliably and repeatedly using those every time you're sharing or publishing materials, making sure that anyone you're communicating to is aware of the rights you have. The big one here is the non-disclosure agreement. And in the same way that I'm suggesting it's great to have a bespoke service agreement prepared, I think at least one time you need to have a good non-disclosure agreement prepared that you can then use and leverage over and over again. Again, people will try and shortcut here and borrow one from a friend or jump online and grab one, and often that'll do the job for you, and I'm very conscious of it. I've seen organisations I've worked with do it. Often it works well. You just need to be mindful that other organisations might not have the same considerations that yours does. Export control provisions, for example, if you're dealing with defence industries, or if you've got subsidiaries that need to be rolled into the sharing arrangements that the non-disclosure agreements cover, they need to be worked into your non-disclosure agreement. And often they're not there if you borrow one. So I think it's always good to get a bespoke one prepared and then just use that over and over for your business. You're going to be dealing with a lot of externals and needing to share information for different things. So having that explicit document is a must. To me, there should never be an implicit agreement where there's a handshake or a head nod, or it's my friend's firm and I know that they're not going to do the dirty on me. Just got to build these foundations right from the beginning. Having these simple but important materials correct from the start is a very good way to go. And look, if you are going to reach out into the internet and see what's out there, at least grab something that's close. I know that IP Australia has an IP collaboration toolkit, and in that toolkit, there is things like a non-disclosure agreement and a collaboration checklist. They're good starting points. If you're going to grab something that's remote, at least go to those. They're going to get you 60% of the way there. But again, in an ideal world, have a chat with an IP lawyer or a commercial lawyer and get a decent non-disclosure agreement prepared for your organisation. In terms of the IP landscape and monitoring and understanding what is in your space, that's a very important step in a good IP management framework. And yes, while you can come to organisations like Wrays or other third-party IP search services, there's a lot you can do yourselves to start with. And often just knowing where to go and how to use different sites is very valuable. So the toolkit item here is a bunch of bookmarks. And what I've shared there on this screen is, you know, my very common go-to points for trademark searches, patent searches, design searches that I do on behalf of clients. Really helpful to get an idea of what's happening in the space, who the customers potentially are, who the competitors are there any roadblocks, are there any pre-existing rights we need to be mindful of. There's a lot you can get information about by doing some initial searching in the right places. These searches might inform subsequent searches that you then have your patent attorneys like Wrays or your search providers conduct for you. But in terms of saving money and just expending a little bit of elbow grease, these are really helpful. I just go to these over and over and over, and I'd encourage you to bookmark them all and have a quick play with them. Really easy to use, Boolean operator type searching or keyword searching where you know particular names. Very helpful. And often they can, avoid you reinventing the wheel, wasting money, and worse, falling foul of someone else's rights because you've done some initial checks. The last one that I've got in my essential bucket is something around policy and strategy. And it sort of just creeps into the essential bucket. Often people say it's a good to have. Certainly in terms of a big weighty IP policy that some companies desire, I guess I'm not convinced that they are an essential item, but you do need some definition about what your strategy or what your approach to IP is. And more often than not, I've worked with organisations to develop an IP policy statement, which summarises in very simple terms on one page what we're seeking to achieve with that organisation in terms of intellectual property protection, what some key IP management practices are that we're going to invoke, and what the responsibilities are with whether it's the board or the managers or individuals within the team. Really helpful to capture that in a snapshot page like this, not only to share internally with people within the business who are important to that IP development part of the business, but also sharing externally. This is one that a client of mine has permitted me to share. This is up on their website. If you go digging far enough, you'll find an updated version of something like this. And this is really good to convey to investors and externals that an organisation does have a good awareness around IP, has practices and procedures in place, and straight away ticks a few boxes for people that are seeking to engage with them. So this is a really handy document to have in your toolkit. Again, it can be as detailed and weighty as you like, but something that snapshots in one page what the intentions are, very handy in my opinion, and something that I've seen rolled out over and over again. Just in terms of some of those good to haves, I've summarised two slides here. One I've called operational and one I've called cultural. And these really depend on the business and what you're seeking to achieve, but these are just examples of things I've seen that have proved very helpful for different organisations that have a bit of an IP position and are seeking to manage it. Particularly if you've got a lot of formal filings or are doing a lot of formal filings in the trademark, the patent, the design space, a country decision matrix is something that can be very helpful. Something that summarizes what are those first tier countries we're interested in protecting, what are the second tier countries we might extend to for certain technologies or certain situations, what are the average costs, where have we historically filed. Having all that captured in a nice, simple matrix that can be pulled out at a meeting where decisions need to be made, again, helps reduce that subjectivity around countries, starts to standardize things, nice repeatability to decisions, and very helpful. Brings real information to bear in terms of costs, and something that's well worth having in your toolkit if you are doing a lot of formal filings. Publication checklist and guidelines. This is really there to help people not shoot themselves in the foot. So if there's some simple checklist items that people can be mindful of when publications such as ASX releases or scientific reports that are being shared in scientific journals or at conferences or the like, knowing what can be said, what notation should be used, what needs to be held back. It's a simple checklist that people can use to make sure that we don't leak information unnecessarily or ahead of time and potentially, invalidate certain rights we might be able to get. These are very handy and very simple to put together and follow. In the same way, brand management guide notes, organizations that have a lot of sub-brands or a lot of products, and they're often adopting new monikers, new trademarks. It's important to make sure you're doing those initial checks in the landscape space to make sure you're not adopting marks that other people have rights to, that you're adopting marks that are going to be registrable, that you're applying them in a certain way, that they can be used by third parties according to certain rules. Having those guide notes summarized in a little brand management checklist or one pager, again, very helpful in that operational space. A couple here in terms of costs. IP expense trackers, again, if you're doing a lot of those formal filings, everyone has a general idea of how much they spent on their IP, but actually breaking that down in terms of your different IP rights, different stages that money's been spent on, filing, prosecution, renewals, and being able to leverage that information, real information, to identify future spend, and not just guess that, oh, my next filing's likely to be 10 grand. You can actually look back and go, well, the last 3 times we did this, it was 7.5 grand, and actually bring real information to bear when making decisions can be really useful. And taking that one step further, having a budget template or a means to prepare a meaningful budget and to be able to provide that, share that with your CFO or your accountant, very helpful. IP is a space where there is a little bit of crystal ball gazing, and often you don't know what's going to happen during prosecution. But there are ways to produce a meaningful budget where you can predict, prosecution spend, filing spend, renewal, some miscellaneous items, and put some meaningful numbers around those. And the last one, this is really for the sophisticated companies that have large portfolios. The ability to get together once or twice a year, have a helicopter review of a portfolio and seek to optimize and make sure that money's being spent on things that are still relevant, countries that are still relevant, and potentially not spending on something and investing in new filings is a really good thing to do. And having spreadsheets or matrices which have gathered together all that information that you need to have those high-level discussions, information around relevance of scope, countries that are covered, costs that are upcoming, decisions that we've made previously, application to licensed products, really, really valuable. Again, this is for the more sophisticated organization, but this can save a lot of money and redirect activity in the IP space really well and make sure that you're getting the maximum bang for your buck. And then just in terms of the cultural piece, trying to raise IP awareness, make sure that the right things are happening, the right messages are getting shared within an organization around IP. There's a number of documents that you can put in to assist and get that right. Right from the start, when employees join an organization and they receive their induction pack, having some IP induction notes that set the scene about the company's position regarding IP, what their obligations are in terms of sharing, keeping things confidential. having that summarized in a nice, concise one-pager that goes into an induction pack, really good to, cement and put forward that IP position right up front when newbies come to the organization. During their tenure, providing them with some IP awareness raising materials, whether they're FAQs that sit on an intranet, whether they're IP education sessions like this one that are provided once a year, or other materials that are shared from time to time, very helpful to make sure that the IP message is kept front of mind. And equally, when leaving an organisation, having those reminders shared with employees, whether in the form of questions asked at an exit interview or a departure letter which mentions certain IP obligations. These are the sorts of things that avoid people running away with IP, or at least put them on notice that if they're going to a different organisation, they need to be careful about what they do, what they take with them. In terms of the more sophisticated companies, again, and some of the things I've seen, where you've got people responsible for IP and sharing information around IP, guide notes about what that champion is expected to do, what they're expected to look after and share, very helpful in setting the scene for that IP champion and just giving them a bit of support. And similarly, if you're large enough that you need a bit of an IP committee to make decisions around spend and things that are going to be filed and things that aren't, having a charter, or some sort of mandate for the IP committee so it's very clear what their roles are, the decisions that they need to make from time to time, very helpful in setting the scene. And lastly, in terms of that cultural piece, reward and recognition means. Again, the companies that do this right, are incentivizing their employees to share information about IP, do the right things in terms of capture, raise issues with their IP champions. And there's a whole bunch of ways you can do that in that reward and recognition space. The main thing in my mind is that you are individually rewarding and recognizing people and doing that in a public way so that others can see there's some benefit to sharing, capturing, doing the right thing with IP, almost making them jealous. I want to get what that person had, or I want to be recognized as well. So these are all about building that cultural piece and making the organization a little bit more IP aware. And again, the companies that I see that get that IP framework really humming, they have all of these things in place, and they do it quite well. So just wrapping up now, obviously, if we get it right, the green box there is where we want to be. We want to have IP as one of our core business assets that helps us maintain a competitive and a sustainable advantage. We do that because we've got the right framework and those toolkit pieces in place to do the identification, the capture, the protection, the management. And if we get it right, we're then able to turn to the exciting part where we leverage and extract value from IP. And you can see that if we get some bits right and some bits wrong, we introduce risk to the system. We have the issues where knowledge walks out the door, or we sort of know what we have, but there's no advantage because we don't formally protect or lock down. So, these are my soapbox items again that need to identify, capture, protect, and manage is going to give you the right foundation to be able to then go the next step and use that IP to whatever it is you need to do, attract investment, ward off evil by establishing a monopoly rights position, use it to promote your business or bargain with third parties. IP can add value in a number of ways. I was just in a meeting the other day where I was so heartened to hear the MD make a comment about how a patent application they filed many years ago, which just recently got granted, was a key turning point for the business in terms of attracting investment, which put it on a path to, which has led to where it is now, substantial growth. That was a filing that was made, it was a patent that hasn't been granted, it hasn't been enforced in a court of law. Just highlighted to me that IP and formal rights can add value in many different ways, depending upon what the business is and what you're seeking to achieve. And again, the end game is, making money from your IP position, attracting investment for the business, and having that solid IP foundation, that those toolkit items, that framework help you develop, allows you to do these more sexy things. The assignment, the sale of rights, licensing activity, franchising, M&As, supply systems, supply arrangements where you're, providing product and getting, profit margins. This is what it's all about. And having those IP assets, locked down, protected, identified, lets us do this in a position and from a position of strength. So that's probably all I had to say. I think I'm right on that sort of 30 minutes. I am happy to take any questions if there are any. I'm just going to scroll down and see if any have dropped into the Q&A box, and I can see 2 here. So I've got a first one. What are your thoughts about subscription-based or third-party proprietary IP registers and innovation management tools? Look, I guess my opinion is they have their place, and there's some good products out there. Companies like CPA and Innovation Asset Group and Decipher, they all have subscription-based products which you can bring into your organization. They interact with your R&D processes, and they're really good tools. They do come at a significant price, and invariably you'll need a resource to manage those tools, but they have their place. If you're a large organization with lots of IP and it's getting pretty tricky, well worth investigating those tools. But if you're a smaller organization and you have a more modest IP position, or maybe even only a handful of formal rights, I think there's a lot that can be done with simple things like Excel and Access databases, and even things like Word, just to provide you with tables and means to track those formal rights that you have. Keep an eye on important details and important dates. And typically that's where I start with organizations. Excel is my go-to thing. And if it quickly becomes unwieldy because we've got so much IP, we can look at other means. But Excel, like I say, Access, Word, good places to start, excuse me. And the last question I've got here, does Wrays offer a web-based IP management tool? We certainly have the ability to work with clients to give them access to parts of the information that are in our database. We have a big proprietary database that manages a lot of information for a lot of our clients. So I think the thing to do is to ask your service provider and get a bit of feedback about what we can do, and importantly, what you're seeking to achieve. Often what people are seeking to achieve might not align with what we can do for them. But if they're seeking to get reports, regular details about some of their IP assets, we can certainly assist in that regard. I've got another question here. In terms of reward mechanisms for employees who have contributed to a company's IP position, what have you seen used that has worked well? I guess I've seen a lot of things, and it's a bit of a horses for courses answer. I've seen things like, hey, that's your job, that's what you get paid for, make sure that you capture the IP and share it. I've seen monetary rewards, the obligatory certificates and plaques and gift cards. I've seen people have their KPIs incorporate IP measures, so the number of filings that they've been involved in affecting, or the number of invention disclosure documents they've filed, contributing to whether they hit certain targets and obviously get certain bonuses. Lunches and functions for inventors and people that have had patents granted. There's a whole host of things you can do. It's hard for me to sit here and say one is better than the other, because it really depends on the size of your organization, what you can deal with. If you're a small organization, you need to be careful about setting a precedent where money's handed over every time an invention disclosure document is filed. But if you're Bosch and you can hand over 1,000 Deutschmarks every time that happens, you can do that. So it really depends what size business you have, how much IP you have and you are going to create, and also what you're seeking to achieve. But again, have a chat with your patent attorney, have a chat offline with myself. I can certainly give some ideas and some pointers around what some of those rewards and recognition items look like. And one last question here. We've got, does Wrays offer a package to investigate an individual invention to determine if novel/patentable and then take through to filing? It's a yes, sort of, is the answer. I don't know that we have a defined package, but certainly the work that our clients do with our service providers, not only our patent attorneys, but our lawyers, we often will investigate, in the early stages, what is the novelty situation, how patentable is this, and certainly work with clients to do those next steps around formal filings if required. So again, this is about having a discussion with your service provider, let them know what you're looking for, and obviously get an idea of what's involved in terms of time and money. I think that's the last of the questions. Hopefully some of the insights I've shared have been useful. Please don't hesitate to reach out offline if you'd like to explore anything a bit further or want a bit further information about any of those toolkit items that I've mentioned. Otherwise, it's probably for me just to thank you for joining us today. There's also our final session, session 4, commencing at 10 o'clock, which is about maximising your time with an IP expert. My colleagues Adrian Huber and Bindu Holavanahali will be presenting on that in about 20 minutes time. I'd encourage you to zoom in and join in on that one. Otherwise, thanks again for your time, everyone. I hope that's proved useful, and I believe these will be made, these webinars will be made available offline as well. So thanks for your time. Enjoy the rest of your day. Cheers.